Since its inception over 30 years ago, the Council of Legal Education has pursued the ideals of its mission statement, which are to facilitate the development of competent legal practitioners for the region who, appreciating their responsibility as members of an honorable profession and recognizing the needs of their socio-economic environment, are inspired in the pursuit of excellence, the maintenance of high ethical standards, the promotion of social justice, and the strengthening of the rule of law. The Council is made up of the Attorneys General and Judiciary of member governments, the practicing legal profession chosen by the relevant professional associations, the Dean of the Faculty of Law of the University of the West Indies, and the principals of the Council's 3 law schools, the Hugh Wooding Law School in Trinidad and Tobago, the Norman Manley Law School in Jamaica, and the Eugene DePuch Law School in the Bahamas. One of the founding members of the Council of Legal Education is Dr. the Honorable Lloyd George Barnett, who, in his illustrious career, has served from 1972 until his retirement in 2006. He has been chairman of the Council for 2 3-year terms and continues to play an important part in its affairs. A significant contribution of Dr. Barnett is the Barnett Report, a seminal document prepared by the Review Committee of the Council under his chairmanship. This report contains analyses and recommendations for the development and improvement of the system of legal education and training in the Commonwealth Caribbean. Dr. Barnett shared recollections of those years at the Norman Manley Law School with his guests, Justice Dennis Morrison, and Registrar of the Hugh Wooding Law School, Mrs. Kathleen Rochford.
Today we are here in the Norman Manley room at the Norman Manley Law School, and we are interviewing Dr. Lloyd Barnett and Mr. Justice Dennis Morrison. Both have been associated with the work of the Council of Legal Education in Jamaica and in the wider Caribbean. Justice Morrison was a graduate of the Norman Manley Law School, and Dr. Barnett is a former chairman. Justice Morrison, too, has been a former chairman of the Council. It is 4 decades since the start of the Caribbean system of legal education. Dr. Barnett, can you share with us the start, the first 2 or 3 meetings of the Council and the vision that they had when they started and devised the Caribbean system of legal education?
Well, I think we should start with saying that the establishment of a system of legal education in the Caribbean was inevitable, and at that time the demands were pressing, because we have to recall that the traditional method of legal training required persons to, in the case of barristers, to go to England and to go to the Inns of Court, and persons who were solicitors to be articled to solicitors in their territories, but they would also have to do English exams. Increasingly, the differences between the legal provisions of the English and British systems were getting less and less identical with the legal provisions in the territories and in the newly independent countries of the Caribbean. In addition to that, the development of the legal profession in the 1960s and 70s in most territories had moved towards almost a few systems. And in many Caribbean countries, barristers in fact practiced as solicitors. And so that a new system was devised which provided training for all aspects of legal work, as well as which sought to provide legal education in a Caribbean context with Caribbean subject matter. So that when the council was formed, it was formed with this specific mandate to establish a truly Caribbean system.
Justice Morrison, you were a student in the first year. Could you share with us some of the experiences being a pioneer of this Caribbean system?
Well, one good thing about the passage of the years is that the name they call you changes, and I'm happy to be now recognized as a pioneer, since in those days we were called guinea pigs and worse names than that. I think that all of those who started out in the Faculty of Law first in the 1970 and then entered law school, whether here or in Trinidad in 1973, were very much enthused with the vision of legal education in the Caribbean. I think we were very conscious of the fact that we were the first persons to be exposed to the system. That enthusiasm was found both among the students and equally among the members of staff at that time. It was, of course, not always plain sailing. One of the things about being part of the startup is that both at the university in Barbados and here at Mona, the accommodation for the training was in temporary facilities. Here at Mona, we were a part of the old Gibraltar camp buildings, some of which are still standing on the campus today. So it wasn't always comfortable, it wasn't always convenient, but I think everybody who came through that program will feel that the spirit of the times definitely justified the sacrifices that were made. In fact, we stayed in those temporary quarters on campus here until the end of 1974, when this building was completed, and we moved over here. So our final year was largely spent in this new building, and I think that it's looking back over the years, which have really just gone in a flash. It's very impressive to see the outreach and of the school at this stage, given our very small beginnings. We were a class of less than 30 in 1973, and I believe in the final year in the law school now the class is in excess of 75, I think.
Yeah. Were there many challenges that you faced as a new entrant to the profession and a graduate from the Caribbean system, as opposed from the English system?
Yeah. Well, I think as in all, with all change there was resistance, and I think, and Lloyd will remember some of this as well as I do, among the existing profession there was a thought that it was certainly not the appropriate way to train lawyers to have them attending classes in sneakers and jeans and on the green fields of Mona. And people felt that there would be a serious deficit in your education if you weren't exposed to the Inns of Court and to the asperities of winter. And there was a feeling that the level of training would just not be the same as persons had been accustomed to in the long-established English system. I think, though, that all of that dissipated very quickly, and I would attribute that to two factors. Firstly, to the fact that there was a dedicated and committed set of people. Lloyd himself was a leading member of that group within the existing profession, who were committed to the system working and who provided a fantastic welcome for the new graduates. In Jamaica, I can think, for instance, of Chief Justice Ken Smith, who was Chief Justice in 1975 when the first graduates came out into practice, and he certainly set the tone in making it clear that it was to be business as usual, in the sense that these were professionals as well trained as any others. And the other factor would be the enthusiasm and willingness to learn of the graduates themselves. And perhaps I should add a third factor, which is that the quality of the training was from the very beginning superb and relevant, and that helped people to become the kinds of lawyers that it was hoped they would be.
In Dr. Barnett, you were chairman in those early days, and after a period of about 10 years, the Marshall Committee was appointed to review the system. And there were major changes resulting from the recommendations of that review committee. Could you share with us some of them?
I'll just go back a little though to what we have been talking about before we get to that. Two things. I think the legal profession had to understand the change in the new system. A considerable body of the legal profession would be the solicitors group. And they were accustomed to having articled clerks who would be very experienced in the nuts and bolts of the practice. And so they were of the view that these graduates from the law school didn't understand, the everyday workings of their office, and they felt that their training was therefore inadequate. But I think eventually they came to understand that it would take some time, but that they had the academic and intellectual, the academic training and the intellectual capacity to manage any deficiency in that sort of practical exposure. And so that led also to another development in that the school started to explore avenues for exposing the students to more and more practical training. By introducing the in-service training and other methods of exposure to everyday practice. Coming to the Marshall Report was really an attempt to review and to see how the system had worked over the first decade. And essentially, I think, came out with an approval rating of the system. Made some recommendations for progress and for improvements, and these were worked on and implemented. But if we might just come back again to the second area that we touched upon, which was the inadequate facilities in which we started. This is also true of Trinidad and Hewing Law School, which also had temporary accommodation. Interestingly, when we decided that it was time to construct a new building, the Jamaican representatives on the council from the beginning were Leslie Ashenham and myself. And I had a big fight with Aubrey Fraser and Leslie Ashenham about how the design should be done, or the selection of the architect, and I was insisting on a public competition. I said this was an important historical development and it shouldn't just be a private thing. And I was saying let's have a public competition. Eventually we compromised and we had a selective tendering system, which resulted in 3 or 4 architects putting up alternatives. I think it would be interesting to look at those different designs. I remember one was a spread out thing, if not a compact building like this, and that was rejected. It was beautiful, but it was rejected on the basis that the maintenance of a building like that would be too great. So that eventually that is how that was done, and I think the same system was then adopted in Trinidad and Tobago for the Hewing Law School.
Dr. Barnett, share with us some more the transition from the temporary buildings to this new building that now houses the Norman Manley Law School.
Well, from the very beginning, Mr. Aubrey Fraser was the Chief Executive Officer of the Council of Legal Education, we may call him that. He was the director, the title he had was Director of Legal Education. So there was a deputy director, so he had overall responsibility for all the development of this new institution, the 2 new institutions, and not only of the physical plan, but of the programs, the recruitment of teachers, and the whole responsibility of establishing the system really fell on him. He had the capacity to do that sort of pioneering work. He also had the advantage of being an essentially Caribbean person who was well known in the Caribbean, and therefore that facilitated his negotiations with the governments and his ability to get things done. He was committed to regionalism, so that he saw this as a very important step for the Caribbean, and so he was devoted to that, and he followed up on a daily basis the implementation of the plans for the establishment of the law school, just as in fact he eventually did for the Ewing Law School, and saw to its proper completion. I think a tremendous amount is owed to him for his contribution to the establishment of the system.
And Justice Morrison, you had the privilege of being a student at that time when the Director of Legal Education was developing the system and the curriculum. Could you share with us some of the experiences that you had at that time?
Well, I certainly agree with what Lloyd says about the debt that is owed to Aubrey Fraser. I have said before, and I think it bears repeating, that I don't think we would have gotten anywhere were it not for his tenacity and his vision of what we could become. As the head of the academic institution with a group of young students in uncomfortable surroundings, he was ideal. I think he was generous. He was nevertheless rigorous in standards and insisting that the standard had to be maintained. But he was always able to understand some of the problems that students would have in that kind of surrounding, financial, some emotional, and matters such as that. But he always had his eye on the main prize, if I might put it that way. And so he was always looking forward, and he was always looking for ways to improve the teaching product. Indeed, I having been associated with the process now over all of these years, I would like to think that the idea of us delivering a product to the students was one of his ideas, one of the things that made it clear that you were not just to come to law school to be the recipient of an education, but that in fact the law school was trying to deliver a legal education product to students who were the consumers. So I think he was an ideal man for the job. As Lloyd has also said, I think that he had responsibilities wider than the Norman Manley Law School, and think looking back and thinking back, it's difficult to appreciate how successfully he straddled that, including in 1 or 2 academic years teaching a full program at the Ewing Law School while being resident and based in Jamaica at Mona at the Norman Manley Law School. He had a lot of energy and he had a lot of drive, and I think those were very important characteristics for the job.
And the records of the council show that he straddled the Caribbean with ease, from Guyana to Belize, in a time when we didn't have time-saving devices like the fax machine and email.
Yes.
And his penmanship is in the records of the council.
Yes.
And
yes.
he was also a photographer.
Yes.
So we have photographs of the havoc that Hurricane Gilbert wrote on the law school and things like that. His photographs.
Yes. And he wrote a wonderful letter.
Yes.
Anybody who has ever gotten even a 2-line from Aubrey Fraser will want to preserve it.
Yes, and he did keep in touch, as Dr. Barnett said. He was able to relate to the needs of the governments and their priorities, and somehow form this cohesive unit and keep it working.
It was very persuasive, because when it started, I was of the view that you couldn't get legal practitioners to come to the law school in the mornings. I didn't see how that was going to be possible. I said, all postgraduate things are always in the evenings, and if you want practitioners to run postgraduate programs in any field, you always made the evenings to facilitate them. But he was able to get judges and lawyers to come to the law school and to do their lectures and conduct their tutorials prior to going to their offices and prior to going to court. I mean, you didn't have judges saying that they're coming to court late because they were in the law school and the students held them back. You know,
absolutely.
So that
and that's still part of the model at this law school, where classes start from 8 to facilitate people coming from outside.
But I mean, the fact that you got so many members of the judiciary and legal profession to cooperate and to devote time, you know, to this project is an indication of how effective he was.
And over the 4 decades, it has proved invaluable to the students to interact with the judiciary from the inception of their training as tutors and associate tutors. Because you also rely very heavily on that novel system of associate tutors, not only full-time. Justice Morrison, you have been an associate tutor. And you remember the days of exchanging scripts, examination scripts for second marking with the tutors at the Hugh Whitting Law School.
Yes, of course, of course.
So to ensure a common system wherever possible.
Yeah. In fact, if I have a regret about how things have developed with that, it is that we're in fact doing less of that in a time when, as you have said, communication and correspondence is much easier than we were in the early days, when it was thought that we should have, and
it was part of the early policy that we should have
common exam
as
papers
possible.
and so on.
I mean, that was a specific decision that the council made at that time. But that reminds me that you had spoken about the development of the curriculum.
Yes.
And that has to be seen in the context of the relationship between the Faculty of Laws and the law schools, because the Faculty of Laws, being essentially an academic institution, had to have the flexibility of choice of subjects for the academic purposes of the degree. But at the same time, the persons who intended to go into practice in the legal profession had to have the basic requirements for the profession. So that one of the early problems we had was to have a relationship established between the Faculty of Laws and the curricula of the faculty with the law schools. And that, in fact, was one of the matters initially had to be dealt with by the Marshall Committee, as well as by the Law Faculty Review Committee. And the device was established by the council of establishing what was called a joint committee in order to seek to coordinate the activities of the two different institutions.
And we had they ceased the post of Director of Legal Education, and they introduced principals of the two law schools. They changed the number of subjects.
Yeah, well,
certainly when you were a student, Justice Morrison,
maybe
you had 15.
Dennis was going to say something more about the Marshall Report.
Yes, well, I was going to say that
out of the Marshall
we
Report.
started out doing 15 courses in the law school. That was the original design, 8 in the first year and 7 in the second year. And I think it was one of the features of council. I don't think we don't want to be self-congratulatory about it, but I think it has to be acknowledged that the council has taken steps over the 40 years to study itself and to reform where necessary. Because one of the things which the first 10 years of experience suggested is that the heavy course load was one, to some extent, taking on in the law school, and this goes back to the division between the faculty and the law school, which Lloyd just spoke of, was taking on some subjects which were more properly the subject of academic study in the university. And secondly, that there was also some element of duplication. And that was having the effect, I think, of reducing the time available for what is now recognized, in fact, as one of the core reasons for existence of a law school, which is skills training. So that one of the things, the most important thing which came out of the Marshall Review and the Marshall Report 10 years later, was that the course load was reduced from 15 to the current number,
11.
which is 11. And what that was done by some rationalization, some subjects such as insurance law, for instance, which was compulsory in the law school, were now put on the curriculum of the faculty, and matters such as that. So that I think that was a very good rationalization of what we were doing, and that model has endured because we have stayed with that. It could well be time to look at that again, because internationally, in fact, the movement has gone even further in favor of lessening your actual substantive law content in favor of greater skills training. And the truth is that over the years we have moved towards doing things like more mock trials, interviewing competitions, and matters such as that, trial advocacy, as add-ons to the existing curriculum rather than trying to make space within the curriculum to do it. So I'm not advocating another review, but we always have to keep looking at all of these things.
But Council advocated another review 25 years into its existence with the Barnett Review Committee and the resulting Barnett report that was approved and adopted at the meeting of the Council held in Barbados in 1996, the 25th anniversary. Dr. Barnett, you lived that review. It took 3 years.
Well, somebody
had to
somebody said that with that review.
And it is fitting that the review committee's report became termed the Barnett Report. Talk to us about that. The stakeholders from 1991-92 started clamoring for a review of the system and whether it was relevant to the then times.
Well, there are a lot of things which necessitated that review. We have to remember that, as is typical of the Caribbean, in every Caribbean arrangement, there's going to be some tensions because of insular requirements, insular differences in priorities, and so on. So that one of the challenges that we had was the development of nationalistic approaches to how you treat with the certificate of legal education of the council, whether you can nevertheless establish your own independent systems and methods of access to the practice of law. That was one major problem. From the beginning, you recall that when we had Mr. Aubrey-Fraser as Director of Legal Education, we had a Deputy Director, and so it was a regional administrative arrangement. But then people said that if Mr. Aubrey-Fraser is stationed at the Northern Manley Law School, that means that you're giving prominence to Northern Manley Law School over your Wooding Law School, so you should have yes, you should therefore have two principals, and so that led to that change where instead of a director you now have principals, so that you lost the coordinating value of having one director without creating anything in its place, because the chairman of the council is a non-executive chairman and therefore cannot provide easily that sort of coordinating force. So that's one of the problems we had. We also had the problems of the Bahamas, which had continued on the old protocol under the agreement, which allowed the Bahamas to continue with its indigenous system of legal education without fully accepting the Caribbean system. We had the problem of persons wanting to return to the Caribbean who had migrated or who were the children of persons who had migrated and who had become trained in other countries and wanted to come back and practice in the Caribbean. So we had to devise a system by which, without destroying the integrity of the Caribbean system, we could accommodate them within the law school methodology of training. So that there were a number of problems which were social and political, which really had nothing to do with law school organization, which the report had to contend with. It also had to continue with the rationalization, which Dennis just spoke of the relationship between the Faculty of Law's curriculum and the law school curriculum, because another important development occurred just about that time, and that was the introduction of the semester system in the university, and the impact which that would have therefore had to be studied, because the semester system seemed to threaten two things: that people would be doing the courses in a truncated way and probably not have the foundation necessary to come straight into the law school, or alternatively that the times, the sequence of the completion of the courses would not coincide as neatly into the old arrangements that previously existed. And so we had to try to work out with the faculty a means by which the two things could easily be coordinated. I mean, those are some of the problems that we had to contend with in writing the report and the recommendations. We also had to contend with this changing social and economic circumstances of the region, the development of new areas of law, and the need for the law school to, as well as the faculty, to be aware of these developments and therefore to adjust to them. Maybe the most important challenge, which I don't think we have met yet, and we're still going to be faced with problems for failing to solve that problem, is that the demands for legal education far exceed the capacity of the current institutions. In fact, far exceed the financial capacity of the governments. At the same time, education has now become a highly commercialized activity, and there are lots of persons, both local and overseas, within the Caribbean and outside the Caribbean, who are aware of the existence of this market and therefore are establishing alternative methods of legal education. And those persons trained in these new systems will, of course, who want to enter the legal profession. Now, the Caribbean system of legal education requires you to come to the law school in order to enter the system of legal practice in the Caribbean. So that is a massive challenge now facing the council.
Yes, Justice Morrison, you became chairman at the time with the Barnett. The recommendations in the Barnett report were being implemented. One of the major ones was the establishment of a third law school in the Bahamas, the Eugene de Puig Law School.
Yeah.
Could you share with us some of the difficulties in integrating a third law school into the system?
Yeah. Well, you're right. I mean, I think I became chairman in September 1998, which is the same month that teaching was to start at what became the Eugene de Puig Law School in the Bahamas. Just as the Norman Manley Law School and the Pewding Law School had been named for the foremost lawyers in Jamaica and Trinidad and Tobago of their generation, so too Eugene de Puig was chosen as the model for the law school in the Bahamas. If I would start with some pluses first, I think that we also had in the Bahamas tremendous cooperation from the practicing profession. That was facilitated by the fact that for the 25 years before 1998, in fact, Bahamian lawyers had been trained here at the Norman Manley Law School. So we had a ready group of persons who were willing to serve as associate tutors and who were quite excited at the prospect of developing a law school in the Bahamas. We also had the good fortune to attract the service of Mr. Justice Austin Davis, who had been for many years at first deputy director and then principal of the Hewding Law School, and who had by then relocated to the Bahamas to serve as the first principal of the Eugene Dupuche Law School. I think that, and that's on the plus side, I think both of those factors contributed to the fact that by 2000 we were able to welcome the first graduates from the system of legal education in the Bahamas. And certainly it's difficult to assess this from a distance, but my own impression from the very beginning and continues to be that law school graduates in the Bahamas are holding their own, just as they did in an earlier generation, both in Trinidad and Tobago, in Jamaica, and throughout the rest of the region. But the challenges continued. There continues to be a major challenge with facilities. We started out in 1998 in a temporary location. Within the course of about a year, we got into, in fact, 3 temporary locations. In fact, the legal aid clinic was operated one place, the administration of the school took place in one place, and the actual teaching and the library facilities were to be found in another location. The distances aren't all that great, but it still is inconvenient and doesn't conduce to very efficient administration. So that has been a problem. There have been problems with identifying appropriate facilities for the law school. There has been, I think, the usual kind of problem that you find when you depend to some extent on government funding of discontinuity, one government going out and another coming in, new ministers, new attorneys general, different priorities. And of course we are all now in the entire world in a completely different dispensation, and it's difficult to predict how that is going to affect the situation in the Bahamas. There is still a problem. Lloyd mentioned the fact that in the middle of the 90s, the Bahamas was still to some extent outside of the system because of the protocol that had been established at the outset. And in at least one respect, although there is a law school in the Bahamas continues to be a little separate from the system in that the monopoly that the legal education certificate was granted, if I might put it that way, that's probably not the best word, in the rest of the Caribbean and under the original arrangements, still has not been achieved in the Bahamas. But overall, I would say that in certainly throughout my 2 terms as chairman, I would say certainly more than 1/3 of my time was devoted to problems in the Bahamas. And but overall, I would say that I think that we've done pretty well there. Again, a tribute to the staff and the students. The other main thing arising out of the Barnett report, which arose in the post-97-98 period, was of course the entrance examination. Dr. Barnett has mentioned the fact that the demand for legal education has far outstripped what anybody could have thought it might have been when the system was originally being designed. And we had a problem, and the review committee grappled with this in 1996 with the fact that apart from the automatic entry that UWI graduates were guaranteed to law schools, other persons had to attain a certain standard of equivalence to the UWI LLB degree. And the old method, the method that worked for 20 odd years, or the dean of the faculty was asked to certify the equivalence of degrees of institutions. Well, I think 2 things happened. I think firstly, the deans always found it to be an onerous responsibility. And there were always allegations of insularity, of favoritism, and so on and so on. And the other thing was, of course, what Lloyd has mentioned, the proliferation of legal education facilities throughout the common law world, so that while in the early days one might have been seeking to assess the equivalence of degrees from London, Oxford, Cambridge, a handful of British universities. No one was faced with universities with brand new names in brand new places and so on. What the council adopted arising out of the review committee report was the entrance examination, which was designed to in fact test the suitability of law school aspirants for law school study. I would have to say that the entrance examination was one of the less popular innovations over the years, but I would also have to say that the fact that it has endured now and continues 12 years later, and I believe a meeting of the academic board is to be held shortly to allocate law school spaces arising out of this year's entrance exam this week in Jamaica. The fact that it has endured suggests that the review committee was right on the money in 1996 when they suggested that of all the alternatives, it was the best alternative. Again, not casting anything in stone, but it has worked over the period.
I remember Keith Sobian was not particularly happy with it, but then he couldn't find any substitutes.
Yes. And to tell you the truth, neither was I. And one of the things that I remember is that at the council meeting in 1996 in Barbados, which you have mentioned, when formal approval was being sought for the Barnett report, I was making some very antagonistic noises in the council meeting, and during a coffee break, Keith Sobian, who by then had come on board, came to me and said, "Why are you trying to scuttle this thing?" so we're all converts in a way, but I think one of the things that it demonstrates is that while there is always a need for imaginative responses to difficult problems, we are in a region with a large number of people. Although we have common interests and common aspirations, we also have some different forces that are operating, and those things mean that you have sometimes a fairly limited set of options to juggle with, and any solution you choose is not going to make everybody happy, but it's what works for the time.
Yes, the whole concept of Caribbean legal education came into being 40 years ago. 2010, the Faculty of Law in the University of West Indies will celebrate its 40th anniversary. 2011, Council, and right after that, it will be the law schools. Times have changed. We have the position of the University of Guyana, clamoring for the same recognition given to the University of the West Indies. We have the priorities of the governments changing. The Bahamas saying that they're not sure that the Caribbean can satisfy all their needs. We have Trinidad violating the treaty. And as chairman and as long-standing members of council, you all have had to deal with these issues. The relationship with the University of the West Indies for funding. And as Justice Morrison has mentioned, the whole global economy changing in front of our very eyes. How do you all see that 40 years on, how has the council managed to survive when so many other regional institutions collapsed? How have we managed to survive? And what can you see as the way forward, to use Keith Sobian's favorite phrase? We must find a way forward.
Well, I really need to defer to a senior man on that.
Well, at the very last meeting of the council I attended, and I hope it is recorded, because at least I think that's my most important contribution. I said that the things have changed so dramatically in relation to the expansion of the market, the challenges of new commercial enterprises, the new methodologies which exist, and the new technologies which are available, that the law schools must now think not in terms of walls, but in terms of methods of communication outside of walls. And that therefore a whole new system of delivery of legal education is necessary. I believe with the demands on our governments and the economic circumstances of the time, it is even more important now that a new approach be taken. The fact that the governments are in difficult financial straits will not in any way diminish the demands on the government to provide additional spaces or opportunities for students. And in my view, the only way that can be met is by providing legal education in a more modern and technologically effective way. It is impossible to do it now by putting people in a room which can only accommodate 20 or 25 persons.
Justice Morrison, Dr. Barnett has said it is time now to look at different means of delivering the product of which you spoke earlier. What are your views on this, 40 years after the inception of a council and that vision?
Well, I endorse that wholeheartedly. I think that part of what has constrained us over the years is thinking that we have to be within four walls, like the four walls that we're in this morning, to deliver the product. Experience has shown that over the 35 years in this building, almost, we've only had it extended once, when the capacity has in fact grown significantly. So if you're a betting man, you would want to suggest that it's not likely that you're going to get the building extended significantly again in this dispensation, as we've been saying. But on the other hand, over that same period, you have had such a revolution in information and information technology. I was quite startled to discover that an old friend of mine from Trinidad, who is a surgeon, was in fact doing a specialized training program run from a university in Wales in surgical techniques, essentially through the internet. The significance of that for me is that it suggests that our traditional notions about how we deliver education in various fields are now completely shot, and there is absolutely no reason why, when we're talking about an inability to afford expansion of the physical facilities, we shouldn't be looking at a resource that is much cheaper and becoming cheaper every day and is freely available to everyone. So I fully support the notion of moving to greater expansion and greater diversity in the methods of delivery of the training. I want to say though that I think an important part of all of this is the role and the position of our governments throughout the region on legal education. The system as originally designed and as it still exists is in fact a partnership between the profession, the judiciary and the governments, with a significant role attributed to the UWI. One of the things which we have been grappling with for many years from Aubrey Fraser's time is to get a handle on what are the actual legal education needs in the Caribbean. The Barnett report itself spoke of that, and since that time we've had a committee of experts which went around the Caribbean trying to get some handle on what the needs might be. Now this is obviously something that concerns governments. Nobody can quarrel with a government that says, well, I shouldn't say nobody. I mean, Lloyd and I might quarrel with it and say you need more lawyers than you need engineers, for instance. But if a government, which has the responsibility of taking these tough decisions, decides that you need more engineers, less lawyers, more teachers, more doctors, less lawyers, that's what governments are to do. But the problem that I have had with what has been happening over the last 15, 20 years is that there are some signs that governments have decided that legal education isn't at the same level of priority that it used to be. One case in point might be the difficulty we have had now in more than 10 years in getting a permanent structure set up in the Bahamas. Another case in point might be the fact that in Jamaica, starting from about 2003, 2004, the Jamaican government capped its contribution to this facility, meaning that every year, no matter how many students you took in, no matter how much the cost of living had gone up, you were still to run the facility with a fixed amount of Jamaican dollars. That in itself is a kind of decision about prioritization. The government of Guyana has done the same thing with its students. So that we need to put it on the table of, I think, the regional discussion. What are the needs and how do we see it?
You see, in the case of the Bahamas, you'll recall that I had strongly advocated that it should be used as the pioneer for a new method of delivery in the establishment of the law school there, and we shouldn't continue to fuss with the government about constructing a building. What is happening now is that you can conduct a surgical operation in Jamaica under the guidance of a surgeon in Australia who is watching and seeing in detail the person's heart is moving, and where you should conduct the incisions and so on, so that even in the most technical and difficult practical areas it is possible now to use the technology. Because of that, I'm not sure that the initial view that we had, that the government's intervention was essential, now stands. I remember that when Howard Fraser had commissioned that study, or the legal education, on his recommendation of the needs, he had done Jamaica only. But the needs, if you go out and do a survey, the needs will be massive. The effective demand is something else, but people will always say they need legal services. So there's no way in which you're going to be able to devise a system to provide that legal service, or that governments are going to accept that in the same way as they might accept the need to provide medical services, they're going to accept the need to provide legal services on the same level. So that if you can, in the situation in which governments had to finance it in such a way that the physical structure had to correspond with the numbers to whom you are delivering the service, then government had a key part to play in the financing. And had to be consulted, and I can't blame governments if they say that training pharmacologists or agricultural scientists or so is more important, and in fact the legal profession will tell you it's overcrowded. But at the same time, people who want to go into a profession, it's very difficult to say to them no. And therefore, this is a solution, because you need not impose heavy financial burdens on the government, and you satisfy the needs. And I mean, it will be left to the profession to regulate itself and to see that, despite the numbers, that things are conducted properly. So I think we have a very revolutionary situation now in which expansion is not as dependent on government financing as it was before.
Yeah, I certainly agree with that. I mean, and I think you mentioned one thing, which is that I don't think it's on the table to go back to overly limiting or restricting entry to a profession that has been seen historically and traditionally in our societies as a road to independence as a person, both in terms of financial resources and your ability to operate independent of other influences. In fact, I think in the late 1960s and 70s, when the scheme was first being devised, one of the things that was on the table was that the previous system of education had its own inherent kind of limitations.
Because in the Caribbean, very strangely, the top of the profession, which was the barristers, was the thing to which the area to which gravitated the people from poor families. You know, you couldn't get into a solicitor's firm because you had to know the people to become a pupil or an articled clerk. So that most young poor people went to become barristers. You know, they could go to England and work and study at the same time.
And by their own effort.
Yes, by their own effort.
And the graduates of the law schools have been nation builders in their own territories. They become that. Both of you all have served as chairman of council in different times and with different priorities. But would you say the council has been imbued with a spirit of compromise? Have you all found that as chair you were able to work through difficult situations through a spirit of
diplomacy was always important and will always be important in Caribbean institutions because, as we said earlier, there are tensions resulting from different priorities, from different interests, from the political demands which are placed on governments and which governments in turn place on the council, so that diplomacy is very important in any regional institution. Whether it's cricket or law.
I certainly agree with that. I mean, I think I became chairman more than 20 years after, no, not 20, 10 years after Lloyd had demitted office. I certainly had the benefit of his example, which is that you need to have your eye on consensus building and on what is possible, because quite often your own view about what is desirable may, on a quick assessment of the situation, be really impossible on the ground at that time. And as chairman, I think it's very important that you try to pull the strands together rather than to foster further divisiveness in what is kind of potentially a divisive
and
situation.
that point of the practicality of what you put forward is very important in relation to what we've been discussing, because if you alter the system fundamentally to deal with this new situation, and you require amendment of the treaty, you know that's going to take 10 years to get that amendment.
Exactly.
You know, whereas you can within your current system introduce the changes.
And not
although the changes will be radical.
Well, you register and know something about that, because I think we've had some treaty amendment proposals on the table for about 15 years now, which haven't gotten anywhere.
And which are vital, because some of the major ones would be the introduction of the staff as members of council, staff representatives, and with the introduction of the Caribbean Court of Justice. That is another arm, and a very important arm of the judiciary.
Yeah, I mean, it makes a point, because you will recall that on both those matters, council took a decision over 10 years ago that one, there should be staff representation, and two, that it should be recommended that we should have a permanent seat for a representative for the president of the CCJ.
I mean, when we had the difficulties and in fact threats, you could put it that way, in relation to the entry of persons from outside the jurisdiction, I virtually had to go around to every territory to lobby the governments to get the amendment for the 6 months course, because I mean the whole thing was on the verge of a breakdown. And it is very difficult to get changes.
And Dennis has had to visit some heads of government.
Yes, I know Chris Blackman also did that.
Ashton Chase when he was chairman, I accompanied him. In those days, it was the question of the government's contribution, because the council was running in overdraft. And so there is always this need to meet with the heads of government one-on-one.